The Union Public Service Commission's decision to cancel the provisional candidature of Puja Dilip Khedkar for the Civil Services Examination 2022 and debar her permanently from all future examinations stroke selections is more stringent than any action that could possibly have been taken by the director of the Lal Bahadur Shastri National Academy of Administration under the IAS probation rules 1954. The director of the academy could have discharged her under Rule 111 or dismissed her under Rule 112. And in case she had to be dismissed, then the procedure laid down under Article 3112 of the Constitution would have had to be followed. Now, what I want to point out here is that both the Lal Bahadur Shastri National Academy and the Sardar Vallabhbhai Patel National Police Academy had failed to take action against probationers whom the directors felt deserved the strictest possible action. And this is the case of the IAS probationer VK Singh and of the IPS probationer Anuj Jaiswal, belonging to the 1981 and the 1980 batches, respectively. Now, first we'll take up the case of VK Singh, because this had created quite a furor, because the then director of the academy, P.S. Appu, took the unprecedented step of writing directly to the Prime Minister of the country on 3rd March 1982. Incidentally, at that time, Mrs. Gandhi was also the Minister for Personnel at that point of time. And it was a very strong letter. The Parliament was in session, and therefore within 2 days, the government reversed its stand and it decided to terminate the services of Mr. Singh on 5th of March 1982. Now, he immediately went to the High Court of Allahabad, and after a gap of 2 years, the High Court decided that the proper procedure has not been followed, and therefore it said that he has to be reinstated. Now, there are two ways of looking at this. The cynic will come to the conclusion that anything and everything is possible, that the system is failing us all. But people like me would also like to learn a lesson from here, that we must pay equal importance to the letter of the law. The spirit of the law is important, but the letter of the law is equally and sometimes even more important, because the court looks at procedural issues with the same gravitas as it looks at the substantial issues. And sometimes the procedure is very, very sacrosanct. Let's go into the facts of the case. What happened was that in October 1982, Mr. P.S. Appu, who was then the director of the academy, got reports that a probationer had brandished a loaded revolver on his colleagues and had really threatened two of his lady colleagues while on an official trek to the Himalayas. And Mr. Appu immediately sent Singh on compulsory leave and conducted a preliminary inquiry. The inquiry was conducted by a deputy director. And in the course of the inquiry, it was established that Mr. Singh had indeed brought out a loaded revolver on the lady IAS probationers. And therefore, that is P.S. Appu, wrote to the MHA on the 28th of October, recommending action against Singh under the relevant rules. But for 2 months, nothing happened. And then finally, on the 28th of December, he again wrote to the government and said that, look, if his recommendation regarding the discharge of Mr. N.K. Singh is not accepted by the government, then he would not like to continue as the director of the academy. By this time, Mr. Appu had also got information that he had earlier been relieved from the NDA after 3 years because of a similar disciplinary proceeding in the National Defence Academy. But again, nothing happened. And 6 weeks later, on the 4th of February 1982, the DOPT sent a confidential letter to Mr. Appu saying that the government has decided to let off the probationer with a warning. This is something which Mr. Appu could not accept, and he said that I will therefore not want to continue in service, and he decided to proceed on leave from the 1st of March, preparatory to his retirement. He said, I'll quit. And mind you, at that point of time, he still had several years left in the service. So on 3rd March, he wrote to the Prime Minister, and this letter shook the conscience of the country. And the letter read, and I quote and I read, it says, "It is unusual for a civil servant, however senior he is, to write directly to the Prime Minister. I am resorting to this unconventional step because I see no other way to bring to the Prime Minister's notice a case of grave misconduct on the part of an IAS officer and the cavalier manner in which the Home Ministry has disposed of this matter. Since I was leaving the IAS on this issue, I thought I would be failing in my duty if I did not bring the relevant facts to the Prime Minister's knowledge." After a brief recital of the case, he concluded that the Home Ministry's decision to, quote unquote, let off lightly a probationer who indulged in a grave misconduct, unquote, would leave the probationers to conclude that, quote, with influence in the right quarters, one can commit even heinous crimes with impunity. This decision will have a disastrous effect on the discipline and morale in the services in general and at the National Academy in particular. In the circumstances, I thought no useful purpose will be served by my continuing in the post of director. As a senior officer, if I fail to take this step, I would, in effect, be acquiescing in the action of the Home Ministry, unquote. Now, the Parliament was in session at that point of time, and Appu's resignation letter created quite a furore. And therefore, the government was compelled to reverse its position and proceeded to terminate Singh's service on the 5th of March 1982. Singh decided to seek legal recourse in the Allahabad High Court, and 2 years later, on 24th April 1984, the High Court quashed the government order, not on substantial grounds, but because it said that the procedure that ought to have been followed in the case of an effective dismissal was not carried out. The High Court said the impugned out order is being struck down only on grounds of non-compliance of provisions of Article 311(2) of the Constitution and of the Rule 112 of the IAS probation rules. And the court said it is being made clear that it will be open for the government to take disciplinary proceedings against the petitioner, VK Singh, even now, under the aforesaid provisions for the alleged misconduct of the probationer. Therefore, the court was not commenting on the merits of the case. The court was only commenting on the procedure that had been followed in this case. However, neither Appu's successor nor the government followed up on this part of the judgment due to reasons best known to them or the cabinet secretary. Of course, these days we also have documentation which shows that the then Home Minister Gyani Zail Singh wrote on the files that Mr. VK Singh comes from a rural background, and therefore very few people from the rural background qualify this prestigious exam. Therefore, he should be given another chance. And of course, the alibi that was being raised all the time was that these English-speaking girls had called him an uncivilized Bihari, and that is what led to the provocation. On the record, Mr. VK Singh did not deny the charge of brandishing a gun. Be that as it may, Mr. Appu resigned, but he continued to inspire a generation of officers. He had already been a stalwart in service. He had written extensively on rural development issues, on development interventions, and for various. And he became a public intellectual, and he was awarded the Padma Bhushan in the year 2006. But that was also the year when the cabinet secretary, who did not take any action, was awarded the Padma Vibhushan. So it's a very interesting tale of sorts. But let's now go to the Anup Jaiswal case. Now, the Anup Jaiswal case is the one in which the Supreme Court had taken the decision that when an IPS officer is being dismissed from service, 3112 has to be followed. And it said that discharge is the same thing as dismissal, because if a discharge is being awarded not on the basis of a specific allegation, not on the basis of a specific action, but on general counts, then it will tend to be dismissal, because in dismissal, there is no in a dismissal, no one is saying that the person who's being dismissed has been accused of any act of omission or commission. But in the case of a dismissal, there's a specific act on which the dismissal is taking place. And if this be the case, then an inquiry has to be made, and the person against whom the inquiry is being made must be given a reasonable chance to rebut the allegations that have been made. In this particular case, Mr. Anuj Jaiswal was charged with not only abstaining from PT on a particular day, but also instigating others from attending the PT at the appropriate time. Mr. Anuj Jaiswal did not deny the fact that he was late for PT, but he vehemently denied the charge of having instigating others to be late. So again, in this case, the Supreme Court felt and took the decision that Mr. Jaiswal should be reinstated because the proper procedure and the inquiry had not been followed. Now, this is as far as the discharge, dismissal, removal, and other aspects are concerned. The other aspect is that how did this Puja Khedkar episode come to light? It obviously is not something which the UPSC found. It is not something which the government found. The credit for this has to go to the intrepid journalists who found from Pune the conduct and the behavior of Puja Khedkar, which led to all this. And once these reports came up, then the social media and the outburst of the citizens was such that the matter could no longer be ignored. And therefore, a lot of credit has to go to the media and the social media, especially for having raised this matter to a point where everybody was stirred. I mean, she was first transferred, the DOPT instituted an inquiry. The UPSC also set its own internal processes in place. Now, the UPSC has acted well. But the question is, the defects or the grave errors did not come out from within the system. First, the system let this happen. Then the system was not able to detect it. But there are many people who are involved in this. After all, the identity could not have been fudged overnight. So many people must have been involved in fudging the papers. So many people have been involved in the medical certificates. And the medical certificates that were accepted were not those from the AIMS. So there is some nexus somewhere which needs to be probed, which needs to be discovered, because all these people also need exemplary punishment so that they're not tempted to do it ever again. One hopes that the Manoj Dwivedi inquiry will bring to light other factors and that the government will take necessary actions. Now, another point which comes up is that it also means that many persons who have been given the benefits of reservation, especially in the category of persons with benchmark disabilities, and many of these names have come up in the social media. I think wherever there is a doubt, wherever there is even the slightest of doubt, it is important that the UPSC gets the AIMS panel to re-examine this, because like Caesar's wife, everything that the UPSC does should be above suspicion. Now that Preeti Sudan, a distinguished officer, has taken over as the chairman of the UPSC, we hope that she will take a stock of the situation and revise the entire manuals and all the processes of the UPSC, because as another colleague of ours from the Foreign Service, Vivek Katchu, pointed out in a recent article in the Telegraph, that many things, many of the eligibility criterion which are there in the UPSC forms need to be revised. You know, we still have a clause which says that refugees who came to India, Tibetan refugees who came to India before 1962, are still eligible to apply. Now, all of them would be in their late 60s. I mean, how can they even apply? We're still talking about subjects of Nepal, whereas Nepal has now become a republic. So these are not going to make a real change. But even otherwise, an institution like the UPSC, whatever the UPSC does, has to be perfect, has to be a perfect score. Therefore, I think it's time that the new chairman of UPSC and her distinguished colleagues will look into these matters and ensure that only the best and the brightest and those who deserve it and those for whom reservation is available in the legitimate sense can cross the portals of the UPSC. Thank you.